"It's already notarized," my brother said, sliding a folded deed across our mother's dining table, the way a man slides a winning hand across a poker table. Certain nobody at that Thanksgiving dinner would ask him a single follow-up question. I asked him which notary had signed it. He didn't answer. "Detective, I think that's the exact moment you need me to start from, because everything that followed grew out of those 4 words and my brother's silence after them. My name is Denise Farraday. I am 55 years old, and I have worked as a licensed title examiner and notary public in Tulsa, Oklahoma for 22 years, which means I have spent more than 2 decades of my professional life doing exactly one thing my brother apparently forgot I knew how to do: reading a deed closely enough to know when something about it is wrong. I want to answer your first question directly, since I know you'll need it for the record. Yes, I am willing to give a full statement about the deed recorded against my mother's property on Fern Avenue. And yes, I understand that anything I say here may become part of a criminal referral against my brother, Todd Farraday. I have thought about that consequence for 3 weeks now, since the night I first pulled the recorded image up on my own company's title plant software. And I want to say, before I go any further, that I did not go looking for a reason to bring my brother into a room like this one. I found what I found because finding exactly this kind of irregularity has been my job since I was 33 years old, and because our mother's house happened, this time, to be the property in question. You asked me, detective, before we started recording, whether I wanted a lawyer present, since I might be implicating a family member. I told you I'd thought about that too, and that I'd decided against it, because everything I'm about to describe is already documented in my own work file, time-stamped the same week I found it, and because I have spent 22 years building a professional reputation around telling people exactly what a document says, regardless of who it might disappoint. I did not intend to spend the 23rd year of that career making an exception for my own family. I think that matters enough to say out loud before I go further. My mother, Louise Farraday, is 79, and she has lived in the same house on Fern Avenue in the Brookside neighborhood since 1979. The house my father built a workshop behind before he passed 2 years ago. Since his death, I have been the one who drives her to her cardiology appointments every 6 weeks, who manages her prescriptions at the pharmacy on Peoria Avenue, who sits with her on Sunday afternoons going through the mail she says gives her a headache to read on her own anymore. My brother lives 90 minutes away in Oklahoma City and has, for most of the last 2 years, called our mother on Sundays and visited on major holidays, which is not nothing, but which also is not the same as knowing, the way I know, which of her medications interact badly with grapefruit or which chair in the living room her hip prefers. I want to say, too, that I never resented Todd for living farther away, not once in these 2 years. Oklahoma City is not another country, but it is far enough that a Tuesday afternoon cardiology appointment simply falls to whoever lives 15 minutes from the office rather than 90, and for 2 years, that had quietly become the shape of our arrangement without either of us ever formally discussing it. My mother has told me, more than once, that she considers both of her children devoted to her in different ways. Todd in his Sunday phone calls and holiday visits, me in the daily texture of ordinary Tuesdays. And for most of those 2 years, I believed that description was fair, even generous, to both of us. There is a particular Sunday I keep returning to, about 4 months before any of this began, when my mother mentioned, almost in passing while I refilled her pill organizer, that Todd had been asking her lately about the house. Whether she'd ever considered what would happen to it, whether probate was something she'd thought through. I remember telling her that probate in Oklahoma for an estate her size was rarely as complicated as people assumed, and that if she ever wanted to formalize anything, we could sit down together and have an actual attorney walk her through her real options, rather than handling it over a kitchen table conversation with either of her children individually. She agreed that sounded sensible. We never got around to scheduling it, and I have thought many times since about how differently that Sunday might have gone if I had pushed harder to schedule that appointment the same week instead of letting it drift. The way ordinary family conversations drift into someday. I noticed the sign before I noticed anything else. It was a Tuesday in September, and I had stopped by Fern Avenue on my lunch break to drop off a refill from the pharmacy. And there, planted in the front yard beside my mother's rose bed, was a realty sign advertising the house for sale, listed at $214,900 through an agent I didn't recognize. My mother had said nothing to me about selling. When I asked her about it that evening, sitting at her kitchen table, she looked at the sign through the window as though seeing it for the first time, and told me she had no idea why it was there, that nobody had asked her permission to put it up, and that Todd had mentioned something weeks earlier about helping her get some paperwork in order in case anything happened to her. Paperwork she'd signed at his kitchen table one Sunday when he'd driven down unexpectedly, though she admitted she couldn't remember exactly what the papers said, only that Todd had told her it was routine. I want to establish something here, detective, before I describe what I found at work the next morning, because I think it matters for understanding why I checked at all, rather than simply asking my brother directly. In my line of work, a for sale sign appearing on a property is a small, ordinary event that happens on thousands of houses every week, and 99 times out of 100, it means exactly what it appears to mean. What made me uneasy that particular Tuesday was not the sign itself. It was my mother's face when she looked at it. The genuine confusion of someone who had signed something without fully understanding what it was, a look I have seen many times across a closing table in 22 years, usually right before I have to stop a transaction and ask someone to slow down and read the document in front of them one more time. The next morning, I pulled the recorded instrument through my company's title plant, the same database I use every working day to research chains of title for people who are strangers to me, and for the first time in my career, I found my own mother's name on the document I was reading. It was a quitclaim deed recorded 6 weeks earlier at the Tulsa County Clerk's office, transferring the Fern Avenue property from Louise Farraday to Todd Farraday for what the deed listed as $10 and other good and valuable consideration, the standard boilerplate language used when no real purchase price changes hands. The signature on the deed was recognizably my mother's handwriting in shape, but the pressure and the slant were wrong in a way I have trained myself to notice, the same way you might notice a photograph of a familiar street taken from an angle that makes something feel slightly off before you can say exactly why. What told me more, though, was the notary block beneath the signature. Oklahoma requires a notary's commission number and expiration date printed clearly on any recorded acknowledgement. And the number on this deed, when I cross-referenced it against the Secretary of State's public notary database that same morning, came back registered to a woman named Beverly Sitko, whose commission had expired 3 years before this deed was ever signed. I sat at my desk for a long moment simply looking at that mismatch, because in 22 years I have seen exactly 2 kinds of notary errors: honest clerical mistakes made by real notaries who wrote down an old expiration date by accident, and documents notarized by someone who was never a valid notary for that signing at all. This was the second kind. I brought it to my supervisor, Victor Castellano, that same afternoon, not because I suspected my own family yet, but because any irregularity on a recorded deed creates potential liability for a title company if that property ever moves through our office again, and reporting exactly what I find, regardless of whose name is attached to it, is a professional obligation I have honored for 2 decades without exception. Victor looked at the file for perhaps 10 minutes before he looked up at me and asked whether I had a personal connection to the grantor listed on the deed. I told him yes, that Louise Farraday was my mother, and that I intended to keep working the file exactly as I would any other, since removing myself from it entirely felt, to me, like a way of pretending I hadn't already seen what I'd seen. Victor agreed that I should document my findings formally and refer the matter to the county's fraud unit rather than handling anything informally within the family, both because that was the correct professional process and because, he told me plainly, family matters handled outside the correct process tend to become messier, not cleaner, for everyone involved. That referral is what eventually brought me into this room with you, Detective Chen, 3 weeks later. Victor asked me one more question that afternoon before I left his office that I've thought about often since. He asked whether I had any reason to believe my brother was under financial pressure that might explain, without excusing, what I'd found. I told him honestly that I did know Todd had been struggling, that his contracting business had lost 2 large jobs the previous year to a competitor undercutting his bids, and that he had mentioned, at Easter, something about refinancing his own house to cover a gap in his equipment loan. I did not know at the time whether any of that connected to Fern Avenue, but I told Victor I thought it was fair to assume it probably did, since people rarely take a risk like the one Todd had apparently taken without some pressure pushing them toward it. I want to go back, though, to the dinner where my brother first showed me a copy of that deed, because I did not yet know that night everything I would find at my desk the following week. Thanksgiving fell that year at my mother's house the way it always has, and Todd arrived an hour before dinner, carrying a bottle of wine and a folder I assumed, at first, contained photographs from his daughter's recent volleyball tournament. Partway through dessert, with our mother in the next room refilling the coffee pot, Todd slid the folder across the table toward me and said he wanted me to see something before I heard about it secondhand, that he'd helped Mom get her affairs in order, and that the house was now properly in his name to avoid, in his words, a mess with probate down the road. I opened the folder and saw a copy of the same deed I would later find recorded at work. My mother's name, Todd's name, a notary stamp I did not yet know was fraudulent, and a signature that, even across a dinner table without any database to check, looked slightly wrong to eyes that read signatures professionally every single day. I asked him, as plainly as I could manage while our mother was still in the next room, which notary had handled the signing, since I didn't recognize the name printed beneath the seal. Todd said he wasn't sure exactly, that he'd found someone online who did mobile notary work, someone convenient who'd come to his apartment rather than requiring Mom to drive anywhere. I asked whether Mom had been present for the actual notarization, whether she had signed in front of this notary directly, the way the law requires. Todd said, after a pause slightly too long to be comfortable, that Mom had signed the document at his kitchen table on a Sunday, and that he'd had it notarized afterward, separately, because it was, in his words, easier that way and amounted to the same thing in the end. I did not raise my voice at that table. I told him quietly that it was not the same thing, that a notarization is a sworn acknowledgement made in the signer's physical presence, not a formality added after the fact, and that whatever he had just described to me was not how any valid notarization in the state of Oklahoma actually works. Todd told me I was overreacting, that I spent too much time at work thinking like a lawyer instead of like a sister, and our mother, returning with the coffee pot at exactly that moment, asked what we were discussing so seriously. And Todd told her it was nothing, just boring paperwork talk, and changed the subject to the volleyball tournament photographs after all. I want to describe one more small detail from that dinner, because it stayed with me more than almost anything else. Before Todd slid the folder across the table, he'd spent nearly 20 minutes that evening talking about a new truck he was considering for the business, a diesel model running close to $60,000, and at the time, I remember thinking only that it seemed like an ambitious purchase for a year he'd described at Easter as tight. It wasn't until much later, sitting with the recorded deed on my screen, that I understood the two conversations might have been connected all along, that a house quietly transferred out of probate and free of any mortgage might have looked, to my brother, like exactly the kind of collateral a struggling business needed, and that Thanksgiving dinner may have been less an announcement of something already finished than an early test of whether anyone at that table would ask the questions he was hoping nobody would. I did not confront him again that night. I drove home, turning the conversation over in my mind, and it was that conversation, more than the sign in the yard, that sent me to my desk the following Monday morning to pull the actual recorded instrument rather than simply trusting the photocopy Todd had shown me at dinner. What I found, as I've already described, confirmed what some professional instinct had already told me across that dining table, that the notary named on the document either did not perform the acknowledgement at all, or was never a valid notary in the first place, and that my mother, as best I could piece together, had signed something at her son's kitchen table without a notary present, believing, based on what she later told me, that she was simply signing paperwork to help Todd assist her with future medical decisions, not a document transferring ownership of the house she had lived in for 45 years. Detective Chen asked me, at this point in my statement, whether I had confronted my brother again before contacting the fraud unit, and I told her no, that once I understood the scope of what I was looking at, I made the decision to follow the same process I would follow for any stranger's file, which meant documenting what I found, reporting it to my supervisor, and allowing the appropriate authority to open a formal inquiry rather than attempting to resolve a potential forgery through a family conversation where the only proof would be my word against his. I told her that decision was not easy, that some part of me wanted very badly to simply call Todd and ask him to undo whatever he'd done quietly before anyone official became involved, but that 22 years of watching families destroy each other over informally handled property disputes had taught me that quiet, informal fixes rarely stay fixed, and that our mother deserved a record that would hold up regardless of how any future conversation between her children went. Detective Chen asked me, at that point, to walk her through exactly what the referral packet I submitted contained, since it would become part of the file supporting any eventual charges. I explained that I had prepared it the way I would prepare a title defect memo for any client: a timeline of the recording date, a copy of the deed as recorded, a printout of the notary commission search showing Beverly Sitko's lapsed status and out-of-state address, and a short written statement describing the Thanksgiving conversation in as close to my brother's exact words as I could recall them. Detective Chen noted that most referrals she received from concerned family members were considerably less organized than mine, usually a phone call and a vague sense that something felt wrong. And I told her that 22 years of preparing documents that hold up in court had simply become the only way I knew how to describe a problem, even one this close to home. The fraud unit's investigation moved faster than I expected once it began. A forensic document examiner retained by the district attorney's office compared the signature on the deed against 7 notarized documents my mother had signed over the previous decade. Documents I had, in most cases, personally notarized myself in my professional capacity, since Mom had long preferred bringing her paperwork to my office rather than a stranger's. The examiner's report concluded that the signature on the Fern Avenue deed showed inconsistencies in stroke pressure and letter formation inconsistent with an unassisted signature. Findings the examiner described, in careful professional language, as more consistent with a traced or guided signature than a spontaneously written one. Separately, investigators confirmed that Beverly Sitko, the notary named on the deed, had allowed her commission to lapse 3 years earlier and had moved out of state entirely 18 months before the deed was supposedly signed, meaning she could not have performed the acknowledgement even if she had wanted to. The actual mobile notary Todd had hired, a man named Wendell Krieger, who advertised discount notary services through an online classified site, admitted to investigators once contacted that he had notarized the document based on a photograph of Louise Faraday's driver's license that Todd texted him without ever meeting Louise in person. A practice Krieger acknowledged he understood was improper, but said he had performed for a modest fee on more than one occasion for clients in a hurry. Investigators found Todd had paid Krieger $300 for the notarization, a small enough sum that it barely registered on Todd's bank statements next to the truck payments and equipment loans he was juggling that same month. Though it was that same $300 transaction, oddly, that gave investigators their clearest timeline of exactly when the forgery took place, since Krieger kept meticulous records of his mobile notary appointments for his own tax purposes, an irony I did not fail to notice, that the one honest paper trail in the entire scheme belonged to the person committing the fraud rather than the person Todd had assumed would never bother checking. When investigators finally interviewed Todd directly, 3 weeks after Thanksgiving, he initially maintained that our mother had fully understood and approved the transfer. But when confronted with Krieger's statement and the forensic document examiner's findings, he changed his account, saying he had intended the transfer only as a way to protect the house from what he called unnecessary probate costs someday, and that he had planned to eventually explain the full arrangement to our mother once it was, in his words, already settled and simple to understand. Louise, when investigators spoke with her separately, said clearly that she had signed something at her son's kitchen table, believing it concerned a medical power of attorney, not a transfer of her home, and that she had never authorized listing the house for sale or agreed to give up ownership of it in any form. I was not present for that interview, but my mother told me about it afterward, sitting at her own kitchen table with a cup of tea she didn't drink. She said the investigator had been kind, had explained each document slowly, had asked her to read the actual deed language out loud herself so there could be no confusion later about whether she understood what she was looking at. She told me that reading the words transfer and conveys and grantor out loud, in her own voice, in her own kitchen, was the moment she finally understood what Todd had actually done. More than any conversation with me had managed to convey. She said she cried afterward, not from anger exactly, but from something closer to grief. The particular grief of realizing a child you trusted completely had decided somewhere along the way that you might say no if he simply asked you directly. Detective Chen asked me whether my mother had considered declining to press the matter further once the fraud was confirmed, since many parents in her position choose to absorb this kind of harm quietly rather than see a child face criminal charges. I told her that my mother had, in fact, raised exactly that question with me twice in the week after the investigator's visit, wondering aloud whether clearing the title quietly through a civil action might be enough without involving the district attorney's office at all. I told her, and I told my mother the same thing directly, that the choice belonged to her, not to me, but that a forged deed left unaddressed criminally tends not to stay contained to one property or one incident in my professional experience, and that protecting Todd from consequences now might simply mean a different, perhaps less patient family member discovering a similar shortcut of his years from now, when she might not be there to catch it herself. My mother sat with that for several days before deciding to let the referral proceed as filed. The county recorder's fraud unit worked with the district attorney's office to file a civil action voiding the fraudulent deed and restoring title to Louise Farraday, a process that took just under 4 months and cost my mother, through the attorney we hired to clear the cloud on her title, $3,400 in legal fees, money I covered myself so she would not have to draw it from her retirement savings. Criminally, Todd was charged with second-degree forgery, a felony under Oklahoma law, and ultimately entered a negotiated plea that avoided prison time in exchange for a suspended sentence, 5 years of probation, and a restitution order requiring him to pay our mother $6,800, covering her legal fees along with the cost of the forensic examination the district attorney's office had ordered. The real estate listing was withdrawn within a week of the fraud unit's involvement, and the agent who had listed the property, a woman named June Ostrander, who had reasonably relied on the recorded deed showing Todd as owner, was not implicated in any wrongdoing once the fraud came to light. June called my mother personally to apologize for the sign in her yard, explaining that she had pulled the county's recorded ownership record herself before accepting the listing, the same record I pull for a living, and that everything in it had appeared entirely legitimate on its face, which is, I think, the clearest illustration of how well the forgery was constructed to survive a routine, good faith check by anyone who wasn't specifically trained to look for what I happened to notice. The civil action to void the deed moved through the county court largely on paper, since Todd, once confronted with the forensic findings, did not contest restoring title to our mother, a decision his own defense attorney later told the prosecutor had meaningfully influenced the plea negotiations that followed. Detective Chen asked whether I thought Todd's cooperation on the civil side reflected genuine remorse or simple pragmatism, given the strength of the evidence. I told her I honestly couldn't separate the two anymore, that I'd known my brother for 50 years and no longer trusted my own read of his intentions, which was, I think, one of the quieter losses in all of this. Smaller than the house or the money, but harder, in some ways, to fully recover. I want to be honest about something that happened after the plea was entered, because I think it matters as much as the legal outcome itself. My mother did not speak to Todd for almost 5 months. When she finally agreed to see him at my suggestion, in a small, supervised visit at my house rather than hers, he apologized, and she told him, in a voice steadier than I expected, that she understood he had likely convinced himself the transfer was somehow for her own protection, but that what actually protected her, in the end, was not his intentions, but a document trail he had never accounted for, a notary database he never checked, and a daughter whose entire career happened to involve reading exactly the kind of paperwork he assumed nobody in the family would ever bother to examine closely. Todd did not have much to say in response to that. He has continued his restitution payments on schedule for the 11 months since the plea, and he calls our mother most Sundays, though the conversations, she tells me, are shorter now and more careful on both sides than they used to be. His business survived, though only barely. He sold the diesel truck he'd been so excited about at Thanksgiving before ever taking delivery of it, forfeiting a deposit of nearly $4,000, and he refinanced his equipment loan through a program his bank offered small contractors that year, a solution his own accountant told him that had been available to him the entire time, without any need to touch our mother's house at all. I have wondered, more than once, whether he simply never asked the right person the right question at the right moment, the way our mother never quite got around to scheduling that attorney meeting, and how much of this entire ordeal might have been prevented by a single different conversation, held a few months earlier by either one of us. I asked Todd once during that single supervised visit at my house why he hadn't simply called me directly and asked whether I thought there was a legitimate way to use the house as collateral, or whether I could help him find another path through the bank, the way his accountant eventually did. He was quiet for a long time before answering. He said he'd assumed I would say no, that I'd always been, in his words, the one who followed every rule to the letter. and that he hadn't wanted to hear that answer from someone who read fine print for a living before he'd even had the chance to try his own plan first. I told him that being the one who reads fine print for a living was exactly why he should have called me first, not last, and that the version of this story where he asked me directly ended in every scenario I could imagine, with our mother's house still standing safely in her own name and his business finding its financing somewhere else entirely. My relationship with Todd since the plea has settled into something careful rather than warm. We speak at family gatherings. We are polite. We have not returned to the easy rhythm we once had as siblings who spoke almost weekly about nothing in particular. I do not know whether that rhythm will ever fully return, and I have made a kind of peace with not knowing. I still notarize documents almost every week at my office. Strangers' deeds, powers of attorney, affidavits for people I will likely never see again after they leave my desk. And I have noticed, since all of this happened, that I read each signature a little more slowly than I used to. Not out of suspicion of the people sitting across from me, but out of a renewed respect for exactly how much weight a single, correctly witnessed signature is meant to carry, and how quietly that weight can be stolen from someone the moment the process around it is skipped for convenience. What I have not made peace with, and do not think I need to, is any doubt about whether reporting what I found was the right decision. 22 years of reading documents for strangers taught me that the truth sitting inside a signature block does not change depending on whose name is attached to it. And I was not willing to become the one person in my own family who suddenly forgot that the day it became inconvenient to remember. Detective Chen asked whether I had told anyone else in the family before the referral went through. An aunt, a cousin, anyone who might have advised me to handle it differently. I told her no, that I had made a deliberate decision to keep the circle as small as possible while the facts were still being confirmed, partly to protect my mother from becoming the subject of family gossip before anything was official, and partly, I admitted, because I was not yet certain how the rest of the family would react to learning that I was the one who had turned Todd in. A phrase I still find strange to use about my own brother, even now, sitting across from you. Detective Chen asked me, near the end of our interview, whether I felt any guilt about the criminal exposure my statement had created for my own brother. I told her the truth, that I had turned that question over more times than I could count in the weeks leading up to this room, and that the answer I kept arriving at was this: I did not create the exposure. Todd created it the moment he decided a signature could be traced rather than witnessed, and the moment he decided a woman with an expired commission living out of state could stand in for the real thing. What I did was refuse to look away from a discrepancy simply because the family name attached to it was my own, something I would never have done for a stranger's file, and something I finally understood I owed my mother even more than I owed any stranger. Once the title was restored, my mother finally scheduled the appointment we should have made together the previous spring, meeting with an estate planning attorney downtown to draft an actual will and a properly executed durable power of attorney. Documents that named me as her agent for both healthcare and finances, witnessed and notarized correctly in the attorney's own office, with an independent notary neither of her children had ever met before that day. She told me afterward, half joking, that she supposed it was fitting that the daughter who noticed the fraud would be the one holding the paperwork afterward. Though I told her I would have been just as satisfied never learning any of it existed at all, if it meant none of this had happened in the first place. She squeezed my hand and said she believed me, and that she also believed some things only become clear to a family after they've been tested in exactly the way ours had. My mother is doing well now, still in the house on Fern Avenue, the for sale sign long gone, the title clear and recorded correctly in her name alone. Last month, going through her mail the way I do most Sundays, I found an envelope from a law firm and asked if she wanted help opening it, the way I always do, and she told me with a small, tired smile that she trusted me to open anything that came to that house from now on, which I understood, without either of us needing to say it directly, was not really a comment about the mail at all. So I will ask you the same question I've been asking myself since that Thanksgiving dinner. If someone in your own family slid a document across the table and told you not to worry about the details, would you have taken them at their word, the way you're supposed to be able to with family? Or would you have gone looking for the one signature that proves whether trust was ever actually earned? This story is a fictional narrative created for entertainment, education, and reflection, with the assistance of artificial intelligence, and any resemblance to real people, names, or events is entirely coincidental. Nothing in this video constitutes legal advice, and anyone with concerns about a deed, a power of attorney, or a notarization should consult a licensed attorney or their county recorder's office directly. Since notary and recording requirements vary from state to state, and only a professional familiar with your own jurisdiction can tell you whether a specific document was properly executed. If this stayed with you, I would love to hear where you're watching from tonight, and I hope you'll come back for the next one.